5 seconds to go. Start. She submitted that it was the desire of the respondent number 1 that the appellant number 1 should work in India. Accordingly, property was bought in Bangalore, where the mother of the respondent number 1 resides. The learned counsel pointed out that after emails dated 25th December 2019 and 14th January 2020 were forwarded by the appellant number 1 to return the money to the appellant number 2 taken from him for land purchased in Bangalore. The aforesaid petition was filed by the respondent number 1 in the court in USA. In the written submissions of the appellants, there are various factors pointed out, such as the temperamental nature of the respondent number 1 and the conduct of the respondent number 1. The learned counsel submitted that this court has held that principles of autonomy must inure in the individual against non-state persons as well. She submitted that in custody cases, a woman cannot be completely eliminated in the name of the welfare of the child. She urged that the woman cannot be deprived of her rights. She submitted that in any case, the appellant number 1 is the primary sole caretaker of the child. The learned counsel submitted that there is a statutory presumption in favor of the appellant number 1 under the doctrine of tender years. She submitted that this doctrine has been upheld in the aforesaid 3 cases, and this court asserted maternal preference as found under section 6 of the Hindu Minority and Guardianship Act 1956, the Act of 1956. She submitted that the appellant number 1 is the primary caregiver and therefore it is in the child's best interest to retain the custody with the appellant number 1. The learned counsel submitted that to compel the appellant number 1, who is the primary caregiver, to return to USA under the rule of best interest of child will amount to an invasion of her fundamental right of autonomy, which is a part of the right of privacy guaranteed under Article 21 of the Constitution of India. By adopting a summary procedure, such invasion on the rights of the appellant number 1 cannot be made. She submitted that the welfare of the child will mean balancing the interests of all in the family of the child. The mother, being the primary caregiver, must be kept in mind by the court, and her legal rights must be respected and protected by the court. She submitted that the appellant number 1 is a fit mother, and in patriarchy some special care is needed to counter the dominant presence of the father of the child. The learned council extensively relied upon an article under the title Beyond the Welfare Principle. Stop.